This week I want to discuss a interesting case with you, both a very human case and also tax-wise, almost a textbook example. It deals with residents and it deals with Article 4 on individuals and the different tests that you follow in the tiebreaker rules. And so this decision first from Federal Court of Australia from 2019, and this is in Pike versus the Commissioner. So the taxpayer was Bradley Pike, and he appealed, and the Commissioner appealed that case, and that went to the Federal Court of Australia in 2020, and that was decided in 2020. And so a brief summary of the facts of what was going on. And the background picture, by the way, here is a nod to a former employer of mine, Scandinavian Tobacco, from one of their websites, and you'll see why I use tobacco as a background picture in a moment. So Mr. Pike and his wife were Zimbabwean. They lived in Zimbabwe until 2005. And then they moved to Australia because Mr. Pike was working in the tobacco industry, and there was no more jobs for him in Zimbabwe. And his wife found a job in Australia, and they moved to Australia with their two sons. But he could not find a job in Australia. However, he did manage to find jobs outside of Australia. So from 2006 to 13, he worked in Thailand. He made quite a career for himself. He then moved to Tanzania upon a promotion, and finally he moved to the UAE. And he spent 76 days in Australia in 2008, 155 in 2009. You can see in each of these years, he spent less than 183 days in Australia. Now, I mean, he and his wife or partner remained within a relationship all this time. They were a family all this time. Whenever he went to Australia, he visited the family. I mean, that's where he stayed. They had a house. They even wanted to build a house together. He made sure that wherever he lived in Thailand, Tanzania, and the UAE, I mean, she could come over with the kids and they could always stay. There was room for them. They were a close family from the looks of everything. But a nasty surprise, Mr. Pike got an assessment from the Australian Revenue Authorities, tax authorities, of 380,000 plus another 72,000 for 2014. As you can see, almost more than $450,000 in back taxes. And the Commissioner argued that Mr. Pike has been a resident of Australia all the time, and therefore he should have paid his taxes in Australia and not in Thailand or Tanzania, where he has been living and working and spending the vast majority of his days per year, as you can see from the table on the right. What makes this case so special is the granularity of the facts around it. So let us look at the facts next, and then let us look at the various considerations of the two judges, because they are very interesting and very detailed about how you deal with the tiebreaker clause in establishing an individual's tax resident, at least in Australia. As I said before, this case is incredibly fact intensive. And I think, you know, when you look at the residents and the tiebreaker rules, facts are everything, right? So I'm going to take some time to just go through all the different facts that were listed and summarize them where possible. So first of all, Mr. Pike was in a long-term standing de facto relationship with Michelle Thornycroft. They have two sons, each born in Zimbabwe. So that was before they left for Australia. By 2004, the economic crisis and shortage of food and basic supplies in Zimbabwe caused Mr. Pike and Mrs. Thornycroft to decide to leave. Ms. Thornycroft sought and was offered and accepted an appointment by Ernst & Young in Brisbane, Australia. So in March 2005, the family travelled to Australia. Mr. Pike and Ms. Thornycroft leased an apartment in the Fortitude Valley in Brisbane. Mr. Pike sought unemployment in Australia. Now, he was a tobacco specialist, as I said, also in Zimbabwe, but at this time the tobacco industry was winding down in Australia, so he was unable to find suitable employment. He became aware in March 2006 of the availability of work in Thailand, where a tobacco industry was being established. That month he traveled to Thailand, and in late 2006 he got a position in Thailand with Premium Tobacco Asia Limited. Now, I mentioned briefly that I worked for Scandinavian Tobacco, and you find this in different commodity areas of the world, but he worked as a tobacco leaf specialist, and it's incredible to meet and talk to these people, because they can look at any kind of tobacco leaf and they can really tell you so much about that plant, where it's from, what the weather was like, what it will be like, whether it's good or whether it's bad, and all that stuff. You know, and I've spoken to one of these specialists once, and he said, you know, I know nothing about tobacco leaves. I've only worked in this field for 10 years. You should talk to the guys that have been there for 20. So he was a specialist, and he earned accordingly, but he moved from the purchasing side, the way I understand it, to the sales side, while working for this company in Thailand. The position was for an indefinite duration. His duties required that he be based in Thailand. And then over the next 8 years, Mr. Pike continued to be based in Thailand for employment purposes. Though he intended to and did return to his family in Australia, circumstance required that he spend most of his time working and living in Thailand. And that's what we saw in the timetable that I showed you on the previous slide. Of how much time he spent on Australia. But I mean, this was a hard-working guy, spending most of his time working, but there's more to it than that. Between 2006 and 2014, Mr. Pike occupied a succession of rented apartments or cottages in Thailand, which he furnished to his taste and also to accommodate Miss Thornycroft and their 2 sons. So they, even though they lived continents apart, they were a family and they were seeing each other as much as possible. He regarded that accommodation as his home when in Thailand. Mr. Pike joined and actively patronized golf, rugby and cricket clubs, and also formed enduring relationships. The man sounds like an incredible person. Maybe just my personal opinion, but it really it sounds like a special person. Also over this period, Mr. Pike and Mrs. Thornycroft jointly rented a home in Taringa. This is after their first home that they rented, Brisbane, and then later a 4-bedroom home at 17 Mile Rocks. Miss Thornycroft, their sons, and when in Australia, Mr. Pike always occupied these premises as a family. And then more facts. Miss Thornycroft's mother moved to Australia from Zimbabwe in 2012 and joined with them. She actually lived with him. During his time in Thailand, Mr. Pike lodged his tax returns with Thailand's Revenue Department. He did not lodge income tax returns in Australia, save for 2014, and that's the year when he became an Australian national. So we'll talk about this in a moment. But it's not as though he didn't pay tax anywhere. He just believed that he spent most of his time in Thailand, and therefore he should file Thai tax returns. September 2006. When Mr. Pike's family initially visited him in Thailand, Mr. Pike and Miss Thornycroft discussed moving the family there, but Miss Thornycroft was not agreeable to this proposal. She wanted to stay in Australia. In 2010, Miss Thornycroft sustained a wrist injury and took extended leave from E&Y. In 2011, after the leave had become to an end, she relinquished her position. Both before and after Miss Thornycroft's injury, Mr. Pike supported her and their sons by regular financial contributions, and the court also shows the amounts, and we're talking about hundreds of thousands of dollars over the period. As well as supporting his immediate family, Mr. Pike continued to support his father, his mother, and his 2 brothers financially, all whom remained living in Zimbabwe. And this is why I'm saying, you know, this sounds like an incredible person. He's into his sport. He seems to fit in wherever he belongs. He's got a big heart. He's taking care of his family. He's loyal to his family. In 16 to February 2009, Ms. Thornycroft, Mr. Pike and their sons were granted permanent residence in Australia. And September 2010, Mr. Pike and Ms. Thornycroft purchased vacant land at Brookwater Residential Golf Community, of course, right? The intention was to build a family home and also to provide something tangible in Australia for their sons. Now, this shows permanency. They sold the Harare home in October 2010. So then they emotionally, I guess, took distance from Zimbabwe. August 2010, Ms. Thornycroft and the couple's two sons were granted Australian citizenship. Mr. Pike made an application for Australian citizenship in April 2013 and gave his residential address, the then rented family home at Taringa. Mr. Pike's citizenship application was refused in 2013, but he lodged a further application in October, and that was granted an Australian passport in 2014. And there's something sensitive about, saying your residential address is in Australia, right? Because then why don't you pay tax as a resident? But at the same time, you have to think of you're applying to become a citizen of a country, and when things are 50-50 and we're not talking tax, we're talking about citizenship. I can emotionally completely understand why he said that he was a resident of Australia, or that his residential address was in Australia, because he didn't say that he didn't have any other residential address. He just said they had a residential address in Australia, right? And then in 2014, Mr. Pike relocated to Tanzania for employment purposes. He closed his Thai bank account and opened one in Tanzania on relocating there. Mr. Pike lived in a fully furnished rented accommodation, which is unlike the one in Thailand, which he furnished himself, for the duration of his time in Tanzania, and joined golf and tennis clubs there. The primary judge stated there's just a paragraph, as with Thailand, he made a home there. This guy is able to fit in everywhere. The judge also noted that Ms. Thornycroft did not want to relocate to Tanzania. I'm not sure whether that means that they talked about, again, moving out of Australia, but in any case, she didn't want to, right? Early 2016, Mr. Pike was offered a promotion to a position based in Dubai in the UAE and took up this offer. February 2016, Mr. Pike entered into a tenancy agreement in relation to an unfurnished apartment in Dubai. So this seems a little more permanent again. The initial duration of the tenancy was 1 year, but it was later extended. The judge stated, yet again, he has made a home there. So once more, a very social, adaptable person. When returning to Australia, Mr. Pike always returned to the home where Miss Thornycroft and their sons were for the time being located, and always regarded this as family home. Over the years, his returns to Australia coincided with family occasions such as birthdays, Christmas, and school prize giving, and have also been occasioned with family emergencies. So he has been there for his family. Does that make him a resident of Australia for tax purposes? That is the question, also under the tiebreaker rule. So and then the last piece of evidence that the judge considered is that the agreed bundle of documents in a court below contained a collection of Australian incoming outgoing passenger cards completed by Mr. Pike dating back to 14 July 2008. It's very interesting to see that they do actually look at these cards when considering residence, right? So the ATO, the Australian Tax Authority, have gone and dug up all these passenger cards from his immigration documents every time he came in and left Australia. And then in the main, in respect of incoming passenger cards, Mr. Pike has chosen the resident returning to Australia section, while at the same time answering no to the question, do you intend to live in Australia for the next 12 months? To me, it seems totally irrelevant. I mean, he was not going to stay in Australia. He was going to go back to his job. I can totally understand why he said resident returning to Australia. It has all simple practical issues, right? You might be able to get it in easier. You might be able to take a shorter line. Instead of taking the foreigners line, you take the Australia resident line. Issues like that. I wouldn't use that as a judgment as to whether someone is a tax resident for Article 4.3 purposes. But the ATO dug it up. Only after the Commission sent an inquiry to Mr. Pike's tax agent as to his tax residential status in February 2017 has Mr. Pike completed an incoming passenger card in which he stated that he was a visitor or a temporary entrant to Australia. Of course, because the ATO scared the hell out of him. On his outgoing passenger card, Mr. Pike has chosen Australian resident departing temporarily section. So, you know, I find using these documents for, like, what do you say when you apply for citizenship? What do you say when you go through immigration and immigration? I think if most people, for practical purposes, say whatever works the best in order to get in there. They don't think, oh my God, how is this affecting my tax status? And as you probably felt by now, I mean, I'm going through the case and decisions and we're going to discuss this. But I think, considering the number of days that he spent in Australia, you know, for the ATO to claim back all those taxes for all those years and claim almost $500,000 Australian dollars from him in taxes, while he clearly did pay his tax in Thailand and I believe also in Tanzania, is quite something. But let's go on to the different arguments used by the different courts with regard to Article 4.3, because that is what really makes this case interesting.